Hi everyone, thanks very much for joining me on the latest Lawshare Q&A. Today we're going to be looking at specifically PI trusts, and I'm delighted to be joined by two solicitors from our private wealth team, Cara, Doyle and Peter McDonnell. Hiya, how are you both? You well?
Yes, not too bad.
Yeah,
excellent.
Thank you.
Well, thanks for giving up your time, and as you're probably aware, in the Lawshare team we're privileged to work with a number of personal injury boutique law firms, and they're forever winning high awards for their clients when they settle and win cases. And I guess what we're going to be looking at today is post-settlement. What is best for their client? How do you manage an award of sometimes very significant amounts of money? So I suppose that leads on to the very first question, which is what is a PI trust and when are they appropriate?
Well, really, a PI trust is like any other trust that someone sets up in England and Wales. So you would have someone appointed as trustee, so the trustee would look after the trust assets, so the trust fund, on behalf of someone who is the beneficiary. Now, the difference between a personal injury trust and, say, another trust that's created in England and Wales is personal injury trusts tend to hold personal injury settlement funds, so whether that's from a personal injury claim or a clinical negligence claim. It could also be a claim through, say, the armed forces, just to expand the remit a little bit there, but that's really the distinguishment between a personal injury trust and an ordinary trust. Anything further to add on that one, Pete?
Yeah, well, like any other trust, it will have a trust deed that sets out the terms of that trust, which include who the trustees are and who the beneficiary is. The trustees will typically be of the injured person's choosing. Trusted friends, family members, can have professionals if need be. The injured person themselves can be one of the trustees, sometimes needs a little bit of care around that, but it's very much possible. And typically the injured person themselves will be the one and only beneficiary of that trust, because that's what offers them the maximum entitlement. And so that type of structure is what we refer to as a bare trust, and is by far and away the most common type of personal injury trust structure.
So we've touched on when a PI trust would be required, but why would a client require such a structure?
So typically the main reason people look to set up personal injury trusts is because the injured person is in receipt of means tested benefits, and even a fairly small interim or final award could cause them to lose that entitlement. The capital thresholds are very low, so when there is potentially that prospect of an interim or a final payment, it's worth the clients receiving means tested benefits considering setting up these structures. They're not just for people though with means tested benefits, because a person may not be in receipt of benefits now, but maybe in future, so maybe thinking more long term about preserving the assets, preserving their wealth. But also some people are receiving a much larger sum of money than they've ever seen in their lives, and even a modest sum could cause them some harm if they have full control over that. And some self-aware clients see the benefits of having another pair of hands on the wheel to help manage those funds. If a person's not in receipt of means tested benefits, the pressure to put a trust in place is somewhat reduced. They can potentially put the structure in place a little bit later down the line, even after they've received the award and use some of it, but the difficulty comes if it's been mixed with their personal assets. We can only put the proceeds of a claim into a personal injury trust, so unless we've got sort of a clear traceable history of those funds, the longer you wait, the more difficult it can be.
So turning your mind to this type of structure sooner rather than later would be the sort of takeaway point, do you think?
Absolutely.
Definitely, and it allows you to split up the proceeds from the claim away from any other assets that they might have. So say if they were to pay the compensation payment into a bank account which has other funds there, then obviously it's not traceable, as Peter's just said, and you're basically contaminating those funds. You can't easily identify those. So we would usually say yes, the sooner the better, purely to make sure that those assets are kept entirely separate and it's just the compensation payment that's going into that trust.
And how would the funds within said trust, how would they be typically utilised?
Well, the starting point with any trust is that the trustees do not hold the assets for themselves, they hold it for the benefit of the beneficiaries in question, and if it's a bare trust, then for the one and only beneficiary. But most awards will start out as a cash lump sum, so there is then a need to look at opening a trust bank account to hold those funds. Typically, the funds should not be used for the beneficiary's sort of everyday sort of expenses and income. That's what the means tested benefits tend to be there for, or other sources of income that they may have. But then you can use some of those funds for some of the nicer things in life that they might want them to be used for. So purchasing property, various investments to try and make the funds grow for a longer period. Potentially some access to cash, but generally try to keep that limited.
No problem. And so you'd need to set up a bank account to be able to, facilitate using these funds. How would you go about doing that?
So there's not many providers anymore that do provide the trust bank account. So whilst clients can set it up themselves, they can speak to different bank providers and see who can set it up for them. We would usually recommend that they speak with an independent financial advisor, just in terms of who they would recommend, but also moving forward, looking at the wider financial planning. A lot of the time the clients are receiving large lump sums and they need that bit of guidance and assistance on how to manage those funds moving forward. So yes, speak to an independent financial advisor. They can recommend a trust bank account provider, but they can also assist them moving forward. We would remain as part of that process, so we wouldn't just hand the client over and say, right, you deal with the bank account.
Yeah,
we would be there to provide any, say, documents or ID documents that are required to open up that account. So we would remain as part of that process, both at the initial setting up of the trust, but also moving forward with opening up the trust bank account.
I know from having spoken to our personal injury team here at JMW, often cases are very serious and involve serious injuries, sometimes life-changing injuries. You touched on some of the day-to-day expenditure and how really that this money is ring-fenced so it doesn't get dragged into that. I guess, would you use that for like purchasing perhaps a new house if it was appropriate for those persons' needs, alterations, that kind of thing?
Yeah, absolutely. So we get a lot of clients that their house isn't fit for purpose, basically. It needs a lot of adaptation, or they need a bigger property. So one of the many questions that gets asked is, well, can I use the funds held within the trust to purchase a new property? And the answer is yes, but you do need the agreement of all the trustees that are appointed. So it's really important to highlight that any distributions that are made from the trust, whether that's distributions of cash or purchasing, say, a new property or a holiday, you do need everyone's agreement to do so. And we've got a fantastic conveyancing team here that can help with that. So if they do find a property that they want to purchase, our conveyancing team are fully aware of property being purchased through a trust, so they can provide some guidance and advice in respect of that. But absolutely, that they can use it to purchase a new property.
Brilliant. And so I guess if someone was to sadly pass away, the benefactor of that trust, how you deal with estates all the time, of course, outside of just looking at this specific trust. How would you then deal with that? Does it become part of that person's estate, or?
It really depends on whether that person has a will or not. So if they have a will, the trust fund will pass in accordance with that will, so to the nominated beneficiaries. But if they don't have a will, then it would pass in accordance with the rules of intestacy. So the rules of intestacy dictate who is entitled to benefit from the estate and in what order. Usually we would recommend that you put a will in any event, and it's something that we pick up on during our initial meeting. So we'll run through, yes, the personal injury trust and how that works and whether that's beneficial for the client, but we'll also pick up on the fact that if they don't have a will in place, let's put one in place for you, whether that's a fairly straightforward, simple structure or a trust structure to provide some extra protection after they do pass away, as well as obviously the personal injury trust itself. So it is something that we can discuss with clients and run through those different structures with them.
And some of it will depend on the trust structure itself that they pick for the personal injury trust. The majority of cases, with it being a bare trust, it will form part of their estate and the trust will essentially come to an end. Should they pick an alternative structure, it can potentially continue after death. Some of the thought needs to be given at that time when setting up the trust to things like the wills, because it might be that the beneficiary has a spouse who also potentially relies on certain means tested benefits, for example, or may be concerned about sort of long-term wealth and asset protection in older age and thinking about the next generation. So setting up a personal injury trust really is only half the story. We can then look to create structures within the will that allow certain amounts of protection, as Cara said, to continue after death, even if the personal injury trust itself doesn't.
Fantastic. Well, thank you both very much. It's been very interesting, very informative. If you have any questions regarding personal injury trusts, or for that matter, anything else that our private wealth team would typically deal with, wills and other structures, then of course Cara, Pete and the wider team are on hand. If you'd like to get in touch with us, you know the email address is just lawshare@jmw.co.uk, and myself and the rest of the team will happily put you in touch with the guys. So just remains to say thank you both very much again.
Thank you very much.
And look out for the next Lawshare Q&A. Thank you.